Okay, good morning. I'm James Wood, one of the editors at Legal 500, and welcome to today's webinar, Doing Business in Iran, Managing the Challenges, Sanctions, Disputes and Exits, hosted by Sabeti Khatami, one of Iran's leading law firms, or the leading law firm, perhaps, in Iran. And obviously, it's been 2 years since the US withdrew from the JCPOA, so we're interested to hear what's going on. We're not just going to be discussing sanctions issues, we'll be discussing a host of other things. I'll leave it to Hooman from Sabeti Khatami to give a fuller introduction in just a moment. Before that, I will introduce all of our speakers very briefly, but just a note from me. We do want to hear from as many of you as possible. So during the webinar, could you please use the Q&A function? Interested to see a couple of frontier investors in the crowd. So can you use the Q&A function to ask questions? And we'll try to address them as and when we have an opportunity. Okay, so quick introductions of our speakers today. So first of all, we'll be hearing from Hooman Sabeti. Hooman is a partner of Sabeti Khatami. He has practiced as a finance and corporate lawyer for over 20 years in Singapore, where I believe he's based today, London and New York. Hooman was previously a partner of Allen & Overy and the general counsel of a supranational financial institution in Asia. Perhaps he'll tell us which one in a second. He has led transactions in some 25 emerging and developed jurisdictions for various governments, global banks and major corporations, with a dozen transactions recognized by awards for their innovation or significance. So great pleasure to have him on the line today. We'll also be hearing from Behnam Khatami, another one of the named partners of Sabeti Khatami in Tehran. He is highly regarded by international clients who are doing business in Iran and regularly advises clients from different industries on market entry and exit strategies, corporate matters and M&A, corporate structuring and restructuring, joint ventures, regulatory and licensing matters, IPC, buyback contracts, power projects, and complex disputes before the Iranian courts. So, and again, great pleasure to have him. We are also joined today by Amer Mitkhayeri. Amer is managing associate at Sabeti Khatami in Tehran. He advises on corporate and financial law with a recent focus on M&A and inbound investments. Amer was previously international legal counsel at Exports Development Bank Canada. He has a Canadian JD, a US PhD, and an Iranian engineering degree. So a very qualified man to take us through all the ins and outs of what's going on today. We'll also hear from Niloufer Mazihi. She is an associate at Sabeti Khatami. She advises on corporate capital markets and contentious matters. Niloufer's recent work includes advising on M&A, sukuk structuring, and disputes before Iranian courts. She was previously an associate at the French firm Auguste Debussy, advising on Iranian regulatory and foreign investment matters. Next, we will also be hearing from Dr. Farid Sigari. Dr. Sigari is a partner of Freshfields in the Vienna office. He specializes in corporate law, private mergers and acquisitions, and corporate restructuring. Farid is also the firm's lead country partner for Iran, and being born in Tehran and fluent in Farsi, he is well accustomed to dealing with Iranian businesses, lawyers, and regulators. He has a broad experience in multi-jurisdictional transactions in emerging markets, with a particular focus on Iran. His international background, mindset, and language skills are significant assets for those clients involved in complex cross-border transactions and investments outside their home jurisdiction. So welcome, Dr. Sigari. We'll also from Freshfields Vienna office, we'll be hearing from Lucas Pomaroli. Lucas is a senior associate there. He's a member of Freshfields Global Sanctions and Trade Group, and his practice focuses on international economic sanctions and export controls. Lucas has significant experience advising on sanctions compliance in the context of transactions in sanctions-sensitive markets and accompanying global internal and external sanctions investigations and regulatory compliance programs. So welcome, Lucas. And last but not least, we will hear from Mohammed Soltani Nejad. He is Vice President of Parvian Advisors, an internationally focused investment and capital markets advisor based in Tehran. He has experience with cross-border M&A, structured finance, domestic IPOs, debt securities, and the commodities market. And Mohammed is also a CFA charter holder. So welcome, Mohammed. Welcome to you all. I will now pass over to Hooman, who will be moderating our session today and getting the thoughts of the speakers. So Hooman, please, over to you.
Okay, thanks very much, James. Enough about us. Let's talk about the subjects. Thanks for attending, and thanks for some of the questions that have come in advance. Our program this morning and or afternoon is in 4 parts. First, we'll hear a bit about what's been happening since May of 2018, when the US withdrew from the JCPOA, and what the current dynamic is, both in terms of economic developments in Iran and developments outside Iran that affect Iran, sanctions, of course, amongst them. Then we'll turn to a discussion of the larger issues that foreign businesses that remain in Iran are contending with. We will next look at the disputes landscape. Most of it is a consequence of the US withdrawal and the subsequent sanctions. And we'll finally examine issues that face foreign businesses that have decided to vacate the Iran market in the face of sanctions, whether they are vacating temporarily or whether they are going on permanently, or whether they're going on a bit of a vacation until Iran becomes more manageable or investable. We welcome your questions, of course, but I would ask that you please raise them as they come up so we can have a livelier session. Don't wait until the end, because we may not have time to address them at the end. So please use the Q&A button, which is the rightmost of the buttons on your Zoom screen, I believe, and let us know of the questions. We may need to get back to you in writing on some of the questions if they're of a detailed nature, which we'll sort of happy to do after this. And for our speakers, please do remember to turn off your microphones unless speaking, and also forgive me in advance if I have to cut people off mid-answer for time reasons. With that, let's go to the first part of our discussion, which is the sort of general overview of things. To frame the discussion and set the economic context, we're going to start with a brief presentation on economic development since the May 2018 US withdrawal from the JCPOA. And for that, I will ask our colleague Mohammed from Parthenon Advisors to take the floor.
Thank you, Hooman. Yeah, let me share my screen. Okay, thank you. I'm going to give you a quick recap on the latest economic and financial developments in Iran since US withdrawal from JCPOA. First stop, GDP growth. The economic rebound post-JCPOA was mainly driven by oil export recovery. With the imposition of sanctions, GDP receded to pre-JCPOA levels, and projected GDP growth for 2020 by IMF is -6%. While oil revenue shrank, other sectors gained more share in the GDP composition. Inflation rates and exchange rates seem out of control. Iran's monetary policies and mismanagement of foreign currency reserves show their macro effects with a push from Washington. Central bank failed to restructure banking system and instead continue to provide unsecured direct overdrafts to banks. Inflation was controlled during JCPOA years mainly by controlling the exchange rate through selling foreign currency reserves at low rates, and this policy depleted reserves. In early 2018, central bank pegged rial to USD at a too strong rate, and that further depleted reserves. Normally, a national currency depreciation could potentially stimulate exports while decreasing imports. That would help with decreasing the trade deficit. But trade deficit persisted in Iran. Battered by sanctions and mismanagement that hurt the real sector of the economy, exports could not catch up with weakened local currency. While imports declined dramatically due to lack of access to foreign currency and bans on importation, trade deficit persisted. Bad old habits, which in this case is flooding the economy with cheap money, never die at the Central Bank of Iran. Central bank continuously increases supply of money for either injecting liquidity to insolvent banks or funding the budget deficit. During the first 8 years of this decade, central bank refused to deal with banking insolvency with a painful yet crucial restructuring, and instead provided direct loans to troubled banks. Since 2018, but direct government borrowing has become the key driver of money supply increase. As the oil revenue declined, the government was forced to become creative and came up with two sets of initiatives. First one, sensible but controversial initiatives, and the second, short-sighted and troubling. Sensible initiatives were cutting energy subsidies that led to a public backlash and social unrest, and introducing tax on capital gains, which never materialized due to lack of the necessary infrastructure and fear of another public backlash. Short-sighted initiatives, on the other hand, were the following: bolstering the stock market or engineering a crazed rally in order to sell government-owned stocks at inflated prices, issuing debt securities at low rates thanks to central bank's policy of suppressing interest rates, and withdrawing funds from National Development Fund, NDF. NDF is an intergenerational sovereign wealth fund and now is being used to help the government with its ballooning budget deficit. In the last 12 months, Tehran Stock Exchange Index increased by 7 times before contracting about 20 to 30%. Some call this rally a price bubble, some call it a paradigm shift, and others cite an early indicator of hyperinflation episode. We still should wait and see which prediction was correct, but the most important driver was the surge in the number of individuals who were largely encouraged by the government to open retail bank accounts and invest their savings in a stock to enjoy the gains that are going to be offered there. In 2019 alone, 11 million new individuals opened retail bank accounts, and in the last 4 months, another 4 million added to that number. The stock market rally seems to be a win-win game for the households and the government. For the government because it can divest its stock holdings at a preferable price, and for the households because nominal gains are considerable. But these gains will be offset soon with high inflation. To give you a better perspective, here's a comparison between Tehran Stock Exchange Index and other major markets since the start of 2020. This year, we became familiar with another financial instrument, let's say, so-called a state ETF. For years, different administrations wanted to privatize state-owned companies, but could not convince themselves to let go of their control in strategic firms such as banks, refineries, steel manufacturers, and automakers. So a state ETF was an ingenious solution to this. Share of state-controlled companies are deposited in ETFs. Units of ETFs are sold to the public, people, and the economic benefit of the stocks are distributed to unit holders, but the government keeps the voting right. The RIACOM was the first ETF of this kind, which was offered in May 2020, and it was sweetened with a substantial discount. Over 3 million individuals purchased the units. In order to sell as much as units as possible, the government gave financial incentives to fintech companies and even e-commerce companies, which don't have even necessary licenses to offer securities, in order to take advantage of their network of clients and market these ETFs. And on the side, a new revenue channel emerged for the government. 0.5% of the value of all stock transactions goes directly to Treasury as trading tax. Total daily amount of this tax didn't used to be much, but thanks to the market rally, this revenue in some days now reaches levels equivalent to revenue from the sale of over 400,000 barrels of oil. and the government is not expected to simply let go of this new revenue stream. Iran had its own financial bazooka to combat COVID-19 and sanctions impacts, and that was government debt securities issuance in a scale not seen before. For years, the government had a lot of obstacles and even technical issues when it wanted to tap the debt market, but desperate times called for desperate measures. All the stockholders, from central bank to Securities and Exchange Organization, came together, compromised, and facilitated debt issuance for the government. That included lowering interest rates by the central bank and also, for the first time, conducting government debt auctions. The total amount of government debt issued in the last 6 months is about 80% higher than the total amount that was issued last year. And COVID-19 disruptions. COVID-19 disruptions wasn't significant compared to developed economies. The government was unwilling to close down the economy for long and reduce restrictions quite quickly. The main part of the period of closures overlapped with the Iranian New Year holiday, during which businesses normally operate at minimum capacity. This approach of the government was motivated by the already perilous state of the economy and its inability to provide financial support to consumers and businesses. But just this week, new infections and deaths hit the record, and the new lockdown has been imposed. And let's have a quick overview of status of different sectors. Oil and gas. We are witnessing severe downturn. Oil export is down to zero. The storage is nearly full. We have a lack of new investment. Petrochemicals also struggle with exports and deflation in product prices. Power and utilities, again, severe downturn. Government is the main client of this industry and is not making payments, and the industry struggles with liquidity shortage. Again, lack of new investment in the sector might lead to power outage. Food and beverage. Food and beverage was able to weather the economic disruptions by boosting exports, but faces diminishing consumer purchase power as the most important threat. E-commerce benefited the most from the pandemic. The only sector still growing is e-commerce, but the growth has slowed. M&A is active in this sector, and we anticipate major IPOs by major e-commerce companies this year, taking advantage of the market rally. Banking. Most banks that were effectively insolvent are now in a much better state, thanks to a sharp increase in prices of stocks, foreign currency, gold, and properties held by these banks. And also low deposit interest rate regime that was imposed by central bank starting from last year, and significantly higher lending rates that CBI imposed again, provided a healthy spread for these banks. And thank you. Hooman, I guess you're on mute.
Yeah, thanks. Sorry about that. So we have a story of economic contraction and a severe local currency weakening, but somehow the economy is sickly afloat. And what we see are novel government responses in the form of very large debt issuance, an engineered stock market rally, and quasi-privatizations. We also see some bright spots. Actually, one of them is the banking system is no longer on the precipice that it was a couple of years ago. E-commerce is doing pretty well, and oil exports are down to zero, practically, which is a bright spot only because what used to be the second largest OPEC exporter is now not really an oil-dependent economy in quite the same way. There are some key variables which will affect the course of things, and Farid will talk about them from an international perspective. I would just point out a couple of them from a domestic perspective, which are that there is an upcoming presidential election of consequence in June of 2021 in the US, where there would be a potentially change of flavor in the government. Another is that there is a China relationship and the recently discussed Iran-China cooperation plan. In reality, the Iran-China relationship is probably most heavily influenced by the US-China and the China-Saudi relationships, but it is potentially of consequence in Iran in the medium term. Now, let's turn to Farid and Lucas at Freshfields in Vienna. Farid is a seasoned Iran hand, and Lucas a seasoned sanctions practitioner, partner and senior associate in Vienna. Gentlemen, from your perspective, what are some initial thoughts on what has been going on in Iran and a summary of sanctions developments?
Good morning and good afternoon to everyone, and thanks, Hooman, for the kind intro. Happy to take on the first part of the international perspective. I think looking at the international markets in general and specifically on the most recent available M&A numbers, which is a good indicator of the investment appetite internationally, we can see that after 6 months of gloom, the Q3 data offers a glimmer of hope, at least. Sectors like the TMT sector, consumer and retail, industrial and materials, healthcare, etc., are leading the M&A value and volume charts and are doing, again, quite well, hopefully. However, there are still some uncertainties. COVID-19 still is an issue, international trade wars, and if we look at Iran's neighborhood, lots of geopolitical challenges in the Middle East, just to name a few. But I will not bore with COVID-19, as this is involuntarily already known to all of us in detail in all variations, and maybe spend a few minutes on international political situations. And I think the most important one has been in discussion for the last few years, probably, and even in the next few weeks and months, the United States will be a particular focus to everyone. In case Mr. Trump wins the election, I think the battle for the geopolitical and economic supremacy will continue and remain a priority of this administration, and that will definitely have an impact on trade and foreign investment worldwide, especially if we look at the US-Sino relationships, and the TikTok situation shows how bad they are at the moment. This is something that will remain concerning in a second Trump administration. But all analysts are expecting a significant thaw, even if there's a change of the presidency. So Mr. Biden has been considered mainly as a China hawk. So there are some concerns that this situation not change very quick. And obviously, as Hooman already pointed out, China is a very important business partner for Iran, and the US-China relationship may and will impact directly or indirectly the Iranian economy as well. Although a change of an administration, on the other hand, could make this Iran sanctions situation better from today's perspective, given that Mr. Biden was part of the was vice president in under Mr. Obama when the JCPOA was signed. The other geopolitical situations in the Middle East that are still a challenge and cause a bit of uncertainty are the ongoing Yemeni civil war, the Syrian civil war, the Iran-Saudi proxy conflict, and the Persian Gulf crisis we had a few months ago. And the current move of the Israeli government and certain Arab countries, Saudi, Emirati, to improve the relationships, specifically focused at reducing Iran's power in the region. And of course, the remaining low oil price, it does put a lot of pressure on countries that are heavily dependent on oil, and that's most of Iran's neighboring countries. And last but not least, but I will hand over to Lucas for that. Business have lots of challenges from sanctions and trade limitations worldwide. And I'm handing over to Lucas to talk about the sanctions development.
Thank you very much, Farid. To give you a short overview and a short summary of the recent and most recent sanctions developments, in a nutshell, the situation is that while the EU sanctions position has not really changed significantly, with most EU sanctions still lifted and the EU still strongly supporting the JCPOA, ever since the US withdrawal from the Iran deal in May 2018 and the subsequent further tightening of US sanctions in 2018, 2019, and 2020, we've seen a loss in appetite by international companies, investors, mainly those with US business activities, but also others to invest and do business in Iran. Being a little specific on the sanctions developments per region, on this side, EU and its member states have repeatedly confirmed they are committed to preserve the JCPOA, but at the same time have urged Iran frequently that Iran needs to return to full compliance with their JCPOA commitments and reverse any actions that are considered incompatible with the Iran deal commitments. But from EU perspective, Iran is still open for most business from EU sanctions perspective. And while the EU has still added some or certain individuals and entities to its sanctions list on other foreign policy grounds, unless the EU has not otherwise tightened or broadened its sanctions recently. Even to the contrary, they're still trying to encourage European companies to do business. And just days ago, the EU has launched an online platform with two tools, the due diligence help desk and the sanctions tool, which aims supporting primarily European SMEs that are interested in doing trade in Iran, but maybe not have the legal compliance capacity due to diligence checks, to encourage them to do trade in Iran with Iran and compliance with EU sanctions rules. So let's see if this helps to encourage EU companies to do further Iran business. On the US side, as I trust all are aware, in May 2018, the US have withdrawn from the JCPOA, have reintroduced all US secondary sanctions that had previously been lifted in January 2016, and following a maximum pressure policy, the US have not just reintroduced the pre-JCPOA sanctions, but have imposed significant additional sanctions against broad Iranian economic sectors, namely the Iranian metal, construction, mining, manufacturer, and textile sectors, and giving their rather broad wording have caused further insecurity among investors and international businesses, what kind of business is possible and is not. And in addition, there is a significant rise in number of designated individuals and entities and organizations. And then most recently on the UN side, the US have unilaterally declared a snapback on UN sanctions, but this has been broadly rebuffed by the EU and the UN. Specifically, the US Secretary of State, Michael Pompeo, has announced that the UN have been notified of the US intention to initiate the JCPOA snapback mechanism. The EU and others have repeatedly stated that this attempt by the US to instigate a snapback is invalid, based on the argument that the US have ceased to be a JCPOA participant after its withdrawal in 2018 and are therefore not in a position to initiate a snapback mechanism. This seems to be supported by the UN Secretary General, who has stated that there would appear to be uncertainty on the issue And even though the US claimed that the snapback has already occurred, from a legal perspective, the snapback is not enacted, and it seems unlikely for UN to execute such snapback unless supported by the other members of the JCPOA, which currently they do not support. So that would be the brief summary on the most recent Iran sanctions developments.
Excellent, thank you. Hooman, you're on mute,
Thanks.
but we have a question from the audience for you, Lucas. I mean, you've touched on it, but Sarah Habibi of Denton, Sarah wants to know what your thoughts are about the new sanctions affecting the entire banking system in Iran. Apparently they're going to be announced today. I know we've heard rumors of these for a long time, but apparently today's the day they fall. What are your thoughts there?
Well, sorry.
Go ahead, Lucas.
My initial thought would be, with the Iranian banking system already being targeted by very broad and strict sanctions from the US, and most Western banks already having difficulty to process Iran-related funds, of course, being subject to the details of these new sanctions, I would not see how this could really further impact or make international business harder from a sanctions perspective.
Okay. Well, apparently I'm no expert here. I believe they're going to target the very few Iranian banks that are not currently subject to secondary sanctions to diminish the latitude of European governments.
Yeah, so the remaining roughly, I don't know, the 12, 15 something banks that have somehow escaped the restrictions are, at least that was rumored in the last few weeks, are potentially will become targeted by new sanctions. And we'll see if all of them will be listed, if there will be any changes. That will definitely impact the smaller loopholes that were available for most of Western banks. We'll still remain interested to see how that will affect any existing banking relationships between Iran and China, Russia, etc. The few countries that tended to stick together through the sanctions that have been introduced. But it will definitely make things more challenging than they are at the moment. But we still have to see what the exact scope of the new sanctions will be.
Okay, excellent, thanks. And just a reminder, anyone else who has questions, please do keep them coming in. We're happy to address them. Sorry, Hooman, I'll hand back to you.
Okay, very good. So let's move to our sort of second area, which is the challenges facing foreign businesses that are still active in the domestic market. From your perspective in Tehran, Behnam, who is my partner at Sabeti Khatami, from your perspective, what are the types of foreign-owned businesses that remain in the country? And can you give us an overview of the issues and the challenges that they are facing?
Sure. First, hi everyone. Thanks for the quick overview of the international front. Well, from domestic perspective, the imposition of US sanctions has drastically changed dynamics in the Iranian market. The effect was that the companies in certain targeted industries such as energy, automotive, telecommunication, construction had to wind down operations and leave the market. Currently, despite restrictions, the most active businesses are limited to consumer goods, food and beverages, commodities, agricultural, tobacco, and some manufacturing, and also e-commerce. In terms of challenges, an environment overwhelmed with international and domestic restrictions has imposed significant challenges to businesses. From domestic perspective, the most significant issues faced by businesses are access to funds, changing and burdensome effects, and capital control regime. Back to you, Hooman.
Thanks. You know, one of the things I would add in terms of the regulatory challenges is that regulations there's no consultation process for regulation. So the regulatory surprises are frequent, and often regulation is overly prescriptive, like it is in a lot of emerging markets, where it actually attempts to point out instructions on how to do things rather than define the parameters of what's permissible and let people make their decisions. Now, this is actually a good moment to answer another question which came in earlier. And the question, I like this question. Iranians seem to be quite happy to take their time on contract awards and don't seem overly concerned about timescales. This puts off some people from the early promises that have yet to materialize. Is this a real problem? I think if you asked someone in Iran, they would say it's not a problem. This is a feature. The reason it takes a long time for things to get done is that decision making is really diffuse. And nobody really wants to be ultimately responsible for a decision, frankly, particularly in government-linked entities. So many people have to come to a consensus, so there's a sense of collective responsibility. Another reason why it takes time is it's the difference between tea and coffee. So if you're doing business in Italy, you will be having, you know, espressos, which take but 2 seconds to have. In Iran, you'll be having a lot of tea, which by its nature comes in small glasses, and you're going to have many of them. What's the purpose of just extending this whole process out? Well, the purpose is to build trust and familiarity. So another reason why things take a long time is that the Iranian parties are trying to get to know their counterpart, and lengthening things out is one of the ways they try to achieve that. Now, let's talk about money. The biggest cluster of challenges revolves around money. Borrowing money in Iran, sending money into Iran, getting money out of Iran. So let's talk about each of those things, and let's talk about borrowing money in Iran. Amir, this is a question for you. Amir's our colleague at Sabeti Khatami. What are the options for domestic borrowing for a foreign-owned business in Iran?
Thanks, Hooman. Well, borrowing is difficult. It requires lots of teas to be drank. In regards to bank financing, one significant challenge is limited resources. Even though, as Mohammed mentioned, books of most banks are in better shape now, banks have plenty of demand from domestic relationships. So they see little need to accommodate foreign-owned businesses. They also often find other activities, such as those in the domestic stock market, more attractive than lending. Another challenge is a generally inflexible mindset of banks. There's very little room for tailoring a bank's approach to lending or documentation, even for a local subsidiary of a very credit-worthy multinational. Most bank facilities are secure, which limits the ability to borrow. Banks regularly ask JVs and subsidiaries to provide parent guarantee, which can be undesirable to give for some parent companies. Finally, almost all Iranian banks are SDNs, perhaps all of them today, which is a showstopper for many foreign companies. As for debt issuance, the debt capital market is underdeveloped. Most of the Islamic debt instruments that are available, or sukuk, are inflexible in meeting the needs of issuers, and issuance costs are high. One particular issue is that most debt securities require bank guarantees, which add to the cost of issuance and requires a bank to make credit assessments as if it were lending itself. Finally, the absence of private placement means that everything is issued in the public market, which creates challenges for foreign-owned businesses due to the high profile of public instrument and the fact that it's quite possible that the instruments end up in ownership of sanctioned entities. Finally, for project financing, the only source used to be National Development Fund. The issues here are the need to meet the mandate, the limited lending mandate of the NDF, and the requirement to meet both the NDF and the banking system processing requirements, because remember that the NDF funds are extended through the banking system. In practice, however, it's not clear whether the NDF is in position to finance projects at this point, at least on a large scale, as it has had to allocate large sums to help the government with its COVID response. And the NDF's access to its own FX funds has been severely restricted due to sanctions.
Okay, thanks. So the options are not good. And that's why we see most foreign companies in Iran rely on funding from abroad, whether it's parent equity or shareholder loans. There is also an unusual domestic option for foreign companies in the form of inter-company lending with unrelated companies, which we can talk about if people are interested. Now, let's talk about sending money in from abroad. And if I could direct this to you, please, Farid. Let's say a foreign parent needs to send funds into Iran for local operations. What are the difficulties they'd face, and what are the options they would have, short of Bitcoin?
Yeah, I guess the quick answer would be what difficulties would they not have? And I think this is really one of the toughest challenges that foreign investors are currently facing. I mean, especially looking at the recent news on potential more severe sanctions, the Iranian financial sector and other additional banks and loopholes being closed. And obviously those investors who are still in the country and still are working with the country and have been able to find a solution, treat the solution more secret than the Coca-Cola recipe. So you hardly know what the money finds to get out of the country. And Western banks are, as all investors will know, are very reluctant still to process funds into or out of Iran. But just to recap on sanctions, sanctions are not the only reason that the Iranian banks and banking system are facing a hardship. It's mainly due to the fact that Iran is still blacklisted by the Financial Action Task Force on Money Laundering, the FATF. Everybody knows, intergovernmental organization that was founded to develop policies regarding anti-money laundering and terrorism financing. And being listed by the FATF as a high-risk jurisdiction, there are significant strategic deficiencies in the Iranian law identified by the FATF when it comes to money laundering and terrorist financing and financing of proliferation. So Iran's been in discussion with the FATF since a few years and started adopting new rules since 2016 to fulfill the action plan. But most recently, earlier this year, the FATF has noted that there are still some significant shortfalls and the action plan has not been completed. This means that the member states and basically all financial institutions internationally have been requested to use enhanced due diligence and reporting mechanisms when it comes to financial transactions involving Iranian banks or with Iran, which mainly is the reason why most of the banks are hesitant to work with Iranian banks, even if the Iranian banks, as they are still today, keep them not sanctioned. So the situation is extremely tricky, and if and if possible, your Western bank would not want to hear the word Iran from you as a client nowadays. So many people, foreign investors have still tried to find their way through exchange houses, but this has also become quite challenging given the AML requirements. And there are obviously few banks, again, a big trade secret, which they are, but there are obviously some banks operating out of China, Russia, and India, maybe other countries as well. The larger the group is, the international group is, the more ways there are to move money out of Iran to subsidiaries which sit in one of these countries and transfer the funds further. And some trade businesses have found other ways, something that would come close to a barter business. And these arrangements are quite hard to find. There is no platform for barter trades. So there's a lot of networking on the ground between the business society and to find ways to use foreign exchange and foreign funds. And this is also quite a challenge and does not work for larger amounts. And again, no real market for that. The EU or Swiss payment platforms that were set up gave hope to many businesses that there could be a way to transfer funds from and into Iran, but for different reasons, both the EU and the Swiss platform are barely used, or there are very limited business deals that can tap into the platform, and only few instances that have become publicly known that these platforms have been used. So that's not available for everyone at the moment. So this will still remain a challenge and even become probably more difficult going forward.
Okay, thanks.
Back to Hooman.
Lucas.
Thanks. Maybe before sharing some additional thoughts on sanctions-related challenges, of which there are quite some, I would just wanted to touch upon a question: what Iranian sectors are targeted by sanctions, and then specifically on the tobacco front. Maybe on the EU side, Iran is generally open for business, and there are just two more important ones: the defense and nuclear sector, that are still targeted by sanctions restrictions from the EU side. Otherwise, EU is open for business, or the EU sanctions front is open for business for Iran. On the US side, on the other hand, it's almost all sectors, except for there are exemptions for humanitarian aid, for medicine, for pharmaceuticals, and the transactions that Farid has just mentioned that have been processed over the Swiss and European platform channels have both been related to COVID-related pharmaceutical and medicinal products transactions. So these are exempted from US sanctions. Other than that, starting from defense, nuclear, energy, ships, banking, finance, insurances. So the most recent one that I've just mentioned, mining, construction, metals, manufacturing. So this is part of maximum pressure policy. The US is trying to target as many Iranian economic sectors as possible, also from a US secondary sanctions perspective. On the tobacco front, this will probably need some closer and more specific assessment to what extent tobacco can be traded. Tobacco machines, for example, could fall under the manufacturing sanctions, but this very happy to take a closer look at this and discuss offline. And then on the additional challenges, we're seeing, Farid has already mentioned, quite some that come from the sanction angle, but also have a broader impact. Generally, we see the I've mentioned there have been additional US sanctions in 2018, 2019, 2020, and not just one block, but they come in pieces. So the sanctions landscape is changing or has been changing very rapidly over the last 2.5 years. And these regular changes have led to huge legal and related economic uncertainty among international investors, economic business, and resulted therefore in a lot of appetite to remain in Iran or start business in Iran. Also, especially for larger international businesses with US business as well, we have seen, while it is possible, of course, to ring fence your US operations from your Iran operations, and a lot of businesses do that, we have seen that a lot of businesses have considered this to be quite burdensome and difficult to monitor and practice, that there is no US involvement at all in any of the Iran operations.
Okay. Okay, thanks. We had a question about cryptocurrency in Iran. Cryptocurrency mining is on the rise because power is cheap in Iran, and there are foreign investors participating. Is an Iranian national cryptocurrency a viable option in avoiding swift and international regulatory scrutiny? And maybe we can have Amir and Lucas address this.
Sure. So I'm not quite sure what Iranian national cryptocurrency was meant here, but I'm just going to address this sort of larger issue of cryptocurrencies. This is really a new regulatory field, both for Iranian regulators and around the world. So after an initial response of prohibiting essentially mining and transferring cryptocurrencies, now the regulators here are grappling with various aspects. So we expect some sort of new waves of regulations being introduced. So it's a little bit too soon and uncertain how this can be used. And remember that any fiat transaction associated with the cryptocurrency transfers are also subject to all the issues that are mentioned, and how they would interact with AML regulations, KYCs and ultimate beneficiaries. It's unknown at this point.
Okay, Lucas, anything from a sanctions or AML perspective?
From a sanctions angle, I would add that would still be restricted under EU and US sanctions to have an economic relationship with a person that is on a EU sanctions list, regardless of the way of payment, because it always relates to making funds or economic resources available. Any form of cryptocurrency would fall under this. Where the business per se is sanctions compliant and it's possible, and it's more on the practical hurdle or the practical restriction to process funds, this would seem a viable option from a sanction perspective. And we've seen, especially smaller companies, at least thinking about using cryptocurrencies to process their payments. Just maybe one last remark. I've also, there have been discussions that on the US side, OFAC, the US sanction authority, wanted to add certain cryptocurrency wallets to the sanctions list in order to not just name date of birth and passport number, but also cryptocurrency wallets, wallet IDs, to make this to make their sanction designation more efficient and to kind of close that loophole where it's being done to process funds with designated persons.
Okay, thank you. Perhaps more challenging than sending money into Iran, if possible, is sending money out of Iran. Businesses may need to do so in order to repatriate profits or to spend it to import, machinery, raw materials. In the wake of the loss of oil revenue since 2018, Iran has introduced quite significant capital controls. Behnam, can you tell us a bit about what the regulatory response of the government to this has been, to the loss in foreign currency earnings, and what are the challenges in sending money out for foreign-owned businesses?
Sure, Hooman. As you said, the current situation has its roots in the past couple of years, and since early 2018, there has been ongoing devaluation of Iranian rial. And in response, there was a successful attempt to peg the rial, then a quasi-managed floating system, which led to 5 different exchange rates, each for a specific purpose. For example, the official rate is a subsidized rate used for importation of certain essential goods, or the NEMO rate is the main commercial wire transfer rate. So Iran has introduced a very strict capital control regime coupled with the import ban. And in practice, it's really difficult to send out money unless it is permitted by law under certain circumstances. The only exception is with respect to foreign investors, which by law their access to foreign currency has been guaranteed by purchasing foreign hard currency from banking system, by exporting investment goods and services, or any other goods or services. But the challenge that the foreign investment holders have is that the procedure is very lengthy, and with few success stories known to us, plus an open market rate would apply for the purpose of repatriation. So this means that basically those investors who have imported their foreign cash capital into Iran and converted that capital into Iranian rial at official rate have to now purchase foreign currency at much higher rates for the purpose of repatriation. So in addition to that, as part of the capital control regime, to preserve foreign currency, the government has also introduced obligation for export sales repatriation, requiring exporters to return back to Iran a portion of their export sales through sale of their foreign currency via the NEMO platform, or through import of foreign permitted goods, which are not many. Export sales repatriation regulations are, however, under development, and therefore they are expectedly ambiguous, incomplete, and subject to frequent changes, which this has also caused uncertainties on implementation of repatriation obligations for the companies.
Okay, thanks. So if a business can't easily repatriate profits and the exchange rate keeps deteriorating, what are the options for hedging the accumulated profits, Amir?
There is no really an FX hedging market, but some hedging arrangements are possible or have been considered. Just to give you a few examples, one potential option is hedging through dynamic management of a portfolio of gold coin certificates. These certificates are offered on a domestic exchange market. They're liquid, they're tradable, and are available in volume. Another option, albeit a weaker one, is purchasing the equity of companies that are export-oriented, so most of their revenues are in hard currencies, but of course the issue here that many of those companies are in sanctioned sectors.
Okay. There's another hedging alternative we've kind of come across, which is, I mean, it's a little bit out there, but it's essentially lending domestically on a hedged basis to other foreign-owned businesses. There are a lot of regulatory issues tied up with that, but it's a possibility. which we can talk about if people want. So we've got a bunch more questions that really focus on sanctions, and I think we could just have Lucas talk for the next 40 minutes and people would be quite pleased. But let's move on to disputes and then come back to that if we have time. Let's turn to our third topic, disputes. In the wake of the US withdrawal and the subsequent sanctions, various companies have left in ways that they did not contemplate when they initially entered into contracts with the local counterparts. Or they were unable or they were unwilling to perform the obligations for which they'd signed up. Let's look at the domestic and the international perspectives on this. Behnam, what changes have you seen in the disputes landscape since the US withdrawal 2 years ago?
Okay. Well, what I can say is that there has actually been a rise in disputes by Iranian parties against foreign counterparts for non-payment or non-performance of contractual obligations, and also for extending agreements or obliging foreign parties to continue their cooperation. On the other hand, there have also been claims brought by the foreign parties against the Iranian counterparts, mainly for contract termination, prevention from seizure of bank guarantees, which has been given as good performance bond, and also debt collections. Added to that, the number of IP infringement claims has also surged since many famous brands have left the market, and in some cases their trademarks have been used by domestic infringers.
Okay, I'll mention a funny story in relation to that, sort of protecting rights, IP rights, or other rights of foreign companies. Oh, we've heard of an example of regulators not being, let's say, unsympathetic to having a state local representative for an international company, because that shows that international businesses are still active in Iran, and sort of presents a nice face. So that gives you a sense of some of the perspectives at work sometimes. Now, Farid, from an international perspective, what have you seen in terms of the disputes landscape in the last couple of years?
Yeah, well, I mean, we'll come to the challenges in more recent cases with arbitration and litigation in a few minutes, but just to recap, what we have been seeing is following the U.S. reintroduction of Iran sanctions and the urge of the international investors to exit certain sectors that were affected or still are affected by the sanctions. For example, the automotive sector, and where the grandfathering periods were quite short. Those were areas or sectors where definitely the parties were in dispute, because from the Iran counterparts' perspective, the exiting of a contract always led to questions about default, and disputes were imminent. So what we have seen is that the parties, the international parties, in most of the cases, try to settle and terminate or exit the contractual arrangement in good faith. Many of them still with a perspective to come back when things get better, and a lot of these agreements and relationships were long-lasting. So nobody was really interested into having a lengthy and probably even useless arbitration or litigation. But there were a few that we were involved in, both arbitration and litigation cases, essentially as an aftermath of the US sanctions being reduced and contracts being terminated. Now, for EU investors, it was quite tricky because they had to find ways to exit their contractual arrangements without making any reference to US sanctions, because from EU anti-blocking rights perspective, that was nothing that they could actively refer to. So those with robust termination possibilities had easier ways to maneuver out of the contract. And essentially in those cases that I was involved in, both claims from Iranian claimants were dismissed due to other reasons, and imminently US sanctions, which were much more important, were never used as an excuse to terminate. So that, again, those are the most immediate observations we had, but I'll come back to challenges around arbitration cases in a few minutes then.
Okay, thanks. The disputes that Behnam referred to often end up in Iranian courts, which raise the question of what litigation in Iran looks like. Nilufar, who's one of our associates, can I ask you to give an overview of court litigation in Iran, and in particular, what would be surprising for an international audience?
Yes, thanks, Hooman. Well, generally, courts do not often deal with disputes with an international element, and so their approach can suffer from a lack of familiarity with sophisticated disputes. Also, the court's decisions are rarely published, so it's hard to know how the courts have previously come out on similar questions. And there is no, generally there is no concept of binding judicial precedent, except in very limited cases. And as a result of all of these, the application of the rules by the courts can sometimes be inconsistent. Another point is that there is no statute of limitation in civil cases, and so there may be cases where the dispute relates to a contract of more than 10 years old, and the parties may have some difficulties for providing the related documents and evidence to the court. With regard to the cost of the proceeding, the costs depend on the type of claims. For claims without a monetary value, it's a minimal fee, but for claims which have a monetary value, the court costs are 3.5% of the claimed amount or the value of the subject matter of the dispute for the trial court. And if the case then goes to the appeal, there's a 4.5% of the claimed amount extra, which should be paid. The costs are paid by the plaintiff or the appellant, and but if they prevail, they can ask the court to require the defendant to pay the cost. But another point that the foreign plaintiffs may wish to consider is that where a foreign plaintiff files a claim in Iranian court against Iranian defendants, the Iranian defendant generally may ask the court to request the foreign plaintiff to make a cash deposit to the court to cover the damages that may be incurred to the Iranian party if the claim is proved to be frivolous. The amount of this is determined by the court, but it's generally 10 to 75% of the claimed amount. But also there's a possibility that this requirement is waived in some treaties, such as, for example, with China and Turkey. So as a conclusion, raising a claim by foreign plaintiffs in Iranian courts can be both costly and uncertain.
So Iranian courts may not be the most attractive venue to find yourself in for settling disputes, and we'll talk about avoiding them a bit later. Now, Behnam, a foreign company leaving Iran or unwilling or unable to perform may be tempted to invoke force majeure based on sanctions. What should foreign parties know about how force majeure is seen in Iran?
Right. First of all, the law does not specifically provide for a solid definition of force majeure. The Civil Code only provides conditions under which an obliger will not be compelled to pay damages if performance of an obligation have been prevented due to an insurmountable external event. So in essence, force majeure is inability to perform rather than an excessive burden. The law also is silent on certain aspects, such as directness of the external event and level of predictability of that event. But the court precedent have tried to make this up and has developed certain criteria in this respect, which I'll explain later. The effect of force majeure is suspension rather than termination. But if the force majeure leads to impossibility of an obligation, the obligee may have the termination right, though no specific time frame is offered by the law for triggering the termination right. Well, back to court precedent. In practice, courts' approach may vary as to what constitutes a force majeure. Sanctions as a force majeure event are controversial, actually. And most courts will not allow it as an excuse for non-performance or delay in performance. And that's because basically of the predictability and not total impossibility of performance generally, but there have been contrary cases, though, I should say. The one takeaway for the audience is that parties are free actually to craft their own force majeure provisions in contracts and lay out a definition and example of force majeure as well as consequences. We would certainly recommend that people take this approach.
There I go again.
Yeah.
Farid, from an international perspective, what about force majeure? And in particular, I think we were talking about the ICC clause earlier.
Yeah, that's a good point, and there are certain pitfalls and things that that people need to bear in mind when agreeing on the ICC force majeure clause when it comes to sanctions. In the past, quite often people said that, well, that's already covered. That is a force majeure event, which in terms of the ICC force majeure and hardship clauses that were developed a few years ago was basically not listed as an event, and it was really hard to argue. Look, most recently, the ICC has introduced sanctions and embargoes as a potential force majeure event in its standard clause, but one of the preconditions, and one of the most important precondition, is that the event as such is not foreseeable. And if you are if you find yourself in a litigation, and if you look at a way that things has been handled by, for example, the United States, look, Trump started saying already in the prior to the last election, he would get rid of the JCPOA and would introduce sanctions as soon as he comes to office. Then the question really arises whether introducing sanctions is an event that is not foreseeable, and you could find yourself in nasty discussions around the event triggering in. So be mindful of using the standard clause and make sure that you tailor that to your part to your specific needs, so that you don't find yourself in nasty discussions later on.
Okay, thanks. So now, Nilüfer, we're going to get to the very exciting topic of conflicts of law. As is often the case, a foreign company contracting with a local one might choose a foreign governing law and a foreign forum for dispute resolution in their contract. What are the important considerations for a foreign company in choosing a foreign governing law and a foreign forum for dispute resolution?
I will first talk about the choice of foreign forum and then the issue of the governing law. But regarding the choice of forum, I should distinguish between a choice of arbitration and a choice of foreign court jurisdiction. So if the parties choose exclusive foreign court jurisdiction and nevertheless one of them files a claim before Iranian courts, an Iranian court may decide to hear the dispute anyway. So exclusive foreign court jurisdiction may not work. But if the parties have chosen foreign or domestic arbitration, Iranian courts are required to recognize that choice and dismiss a claim brought before them. Now regarding the issue of the applicable law, I will first talk about the court proceeding and then the arbitration. So in a court proceeding, the courts are obliged to consider the Iranian conflict of law rule for determining the law applicable to the contract. And based on this rule, the obligations arising out of contracts are governed by the law of the place of conclusion, which is where the last signature was affixed to the contract. So in a dispute between an Iranian party and a foreign person, if the last signature was to the contract was made in Iran, the court will apply the Iranian law, even if the parties have agreed on a different governing law. But the position is different in an arbitration proceeding. So even if the seat of arbitration is in Iran, the arbitrators would recognize the parties' choice of foreign law. So based on these issues I just talked about, there are 2 points that the foreign parties may wish to consider. And first is that to ensure that the choice of foreign law would be recognized, it's safer to choose arbitration. And the second is that an exclusive choice of foreign court jurisdiction may not be effective if one of the parties nevertheless files a claim before Iranian courts.
Okay, thanks. So arbitration is a particularly attractive option. What are the issues, Behnam, that foreign companies might encounter in enforcing an arbitration provision with an Iranian party or in enforcing an arbitral award? And what about an Iranian court judgment being enforceable outside of Iran?
Okay, good question, Hooman. As Nilufar mentioned, although a choice of arbitration will generally be respected by Iranian courts, the arbitral awards will generally be enforced, and but there are exceptions. In domesticating a foreign arbitral award, Iranian courts may reject an award if it contradicts public order or mandatory rules of law, which can be interpreted broadly. For example, in most contracts between foreign entities and government entities, the choice of arbitration requires prior approval of the Council of Ministers and the Parliament. If the parties do not obtain these approvals in advance, the choice of arbitration may not be recognized, and therefore an arbitral award may not be enforced. There is another mandatory rule which could basically frustrate an arbitration agreement, and that is, by law, an Iranian party to an arbitration agreement with a foreign person may not, in advance of a dispute, commit to refer potential disputes to arbitration by arbitrators with the same nationality of the foreign, with the same nationality as the foreign person. Courts may interpret this law broadly as well, to also include referral to arbitral institutions in the country of nationality of the foreign person. So, for example, an arbitration agreement with a French party that refers disputes to arbitration in Paris may potentially be frustrated. We're not saying it will necessarily be frustrated, but we have seen issues from that perspective, and the ruling of Iranian courts building arguments based on this, and which led to frustration of arbitration agreement. On enforceability of Iranian court judgments abroad, which you asked, I should say Iranian judgments are in fact enforceable abroad if there is a treaty to that effect, But absent a treaty, a foreign jurisdiction may, in compliance with its laws, enforce Iranian judgments. Interestingly, we have seen cases in which the foreign parties ignored this because they didn't have local presence in Iran, and they were thinking that, okay, if the Iranian counterpart obtains a favorable judgment for itself, or a judgment against us, what they can do. So because of this fact that the Iranian judgments may be enforced abroad, claims brought by Iranian parties before Iranian courts actually must be defended by foreign defendants, even though they do not have any presence in law.
Thanks. It is now raining very hard in Singapore, so I'm sorry if there's background noise. Farid, there have been some issues with foreign arbitral institutions taking on disputes involving Iranian parties. Can you speak to those issues and how people have come to deal with them?
Well, yeah, sure. We have seen several cases where arbitration claim was brought in front of an international arbitration institution, but essentially due to the inability of the parties to transfer funds, speaking of Iranian parties, of course, to the institution, the proceedings had to come to a halt. Even though all parties were really interested to stick to arbitration and continue and get the case clear, this situation specifically is more irritating for Iranian claimants who called an arbitration court. But there could also be an advantage in doing so. The claimants will mainly consider whether it could be an advantage to initiate the arbitration just to make sure that they do not risk the claim becoming time barred. So the proceeding is initiated and has to come to a halt, but at least you don't run the risk that limitation periods kick in. This is of course not satisfactory if you're aiming at a quick settlement or a quick judgment, but initiating a arbitration could also at the same time incentivize the potential respondent to reach an out-of-court settlement, because just depending on the size and shape of the company, for example, a listed company, they probably don't want to stick to an open dispute and have reserves in their accounts for an indefinite period, as it's uncertain how long that could take. All not satisfying, but something that could be thought about. But what we also see is that the parties, in case of a dispute, try to agree to an ad hoc proceeding so that they don't have to tap into an international institution and use an arbitral tribunal with arbitrators that are active in countries that, at least for the moment, are more favorable in terms of receiving funds out of Iran. So that's also something that we have seen in the recent case.
Okay, thanks. Before we go on to our last topic, let me just suggest, based on what we've seen in the last couple of years, a few additional things that foreign companies might want to keep in mind if they're entering Iran or anticipating a contentious matter involving Iran. One is that in new contracts, it makes all the sense in the world to deal with sanctions explicitly and specify their consequences. It also makes sense in new contracts to include liquidated damage provisions. The quantum of damages is very difficult to establish in Iranian courts, especially in the case of sophisticated commercial arrangements. And you don't want to rely on judiciary experts and so on to do that. Finally, I think careful attention to renewal provisions, termination provisions, default provisions is in existing contracts, if you have them and you anticipate problems, or if you're entering them, is quite important. We've seen multiple instances where these have become very consequential for the foreign party. Now we have a few questions which we're going to try to come back to. We're about an hour and 20 minutes into it, and we were gonna try to do this in an hour and 30, but we'll happily go on as long as there are questions and people are interested in listening to the answer. So we'll cover our fourth topic, which is exits, and then we'll come back and pick up some of the questions that we've seen. So the last topic is the issues facing foreign businesses that have decided to depart the Iranian market in the face of sanctions, whether permanently or temporarily in anticipation of a return under better circumstances. There are a range of options. In the worst case, there is liquidation. In the middle case, there is a sale or transfer of the business or of contracts. And in the hopeful case, there is some sort of restructuring of ownership or governance, which leaves the door open to a return in the future. Farid, let me ask you this. From your perspective, what are the drivers and the goals that foreign companies in Iran think about when they are assessing their departure options?
Hooman, well, that's a good question. I mean, effectively, if you're facing sanctions, the key driver will be the timing. Often sanctions come quickly and just leave a very, very tight time period, a grace period of a few months that makes a good decision-making progress impossible. So it's quite a challenge to organize anything that could be could be called a thoughtful process to exit a market, be it through sale or liquidation or whatever. So sale would be a nightmare anyway, because as a seller in a scenario where everybody knows that you have, I don't know, 2, 3, 4 months to leave the country, you can only think how the situation will be. First of all, you won't find an international buyer because sanctions will kick in. You will look at domestic buyers, and the domestic buyers will all know that time is of the essence and will use that element to push through their own position in negotiations. So that comes at a severe loss anyway. And then looking at liquidation, this is something that basically obstructs the business and will also take substantially longer than the grace periods. And nobody wants to take the risk and see how that comes if you are specifically focused from outside. So what we have seen is, of course, where possible, there were sales coming at a loss. There were liquidations when people thought that still they've taken the appropriate measures to overcome any sanctions hurdles and can have good arguments when they're approached by sanctioning authorities. But what we have also seen is restructuring of ownerships, essentially when international investors are really keen to re-enter the market when the environment is much more sanctions friendly. This is obviously quite challenging, and in cases where the international partners had good long-standing relationships to local partners in joint venture situations, the moving out of the company, whichever measure, with a gentleman's agreement to re-enter was something that people agreed upon. And obviously other measures of restructuring the ownership outside the country was something that many clients have been looking into. So yeah, there have been different ways to maneuver around and different drivers, but the key point is timing, and the goal could be having a foot in the door to re-enter the market, or wanting to leave the market forever.
Okay. Let me just address from a domestic perspective. I think companies, will think about future possibilities and whether they want to preserve some optionality, as you mentioned. If the companies are going to have an economic interest but no decision making, then they will want to ensure that the business carries on within certain acceptable parameters, both from a sanctions and a governance perspective. And JVs, we find, are particularly challenging because the business may not be viable without the foreign partner. The sanctions exposure of counterparts is also obviously a consideration, which is what the sort of thing that will come across Lucas's desk. Another consideration is that there isn't anything quite as reliable as a common law trust in Iran to preserve future rights. And other arrangements that try to achieve something of that nature can have real risks of counterparty non-performance. Finally, the other sort of thing that is going on is that the domestic counterpart may prove to see things differently and may be a difficult negotiating counterpart, and especially if consents are necessary from them to get the reorganization or restructuring done. Now, let's look at the worst case and then get to better cases. In the worst case, Behnam, what are the challenges and issues in case of a liquidation?
There are basically two major challenges. First is the cumbersome and lengthy procedure, which involves timely publication of several announcements. And basically this procedure may take more than a year, depending on the type of the company. In addition to that, extra steps have to be taken by regulated companies, which include obtaining regulatory permission for regulation. The other challenge is tail liability of liquidator in terms of tax liabilities of the company, even after conclusion of liquidation. So in this specific issue, the tax office may also review and reassess tax files up to 5 years from issuance of tax assessments. So effectively, the liquidator's liability can extend 5 years beyond conclusion of liquidation. This is, however, usually addressed through indemnification schemes with the liquidator before conclusion of liquidation.
Okay, thanks. So, Nilufar, what are in the case when we're talking about assigning contracts, so this is sort of middle case, assigning contracts, for example, contracts awarded through tenders, what are the main issues to think about?
Well, generally, there are 3 points that I should make on this issue of assignment. And first is that under Iranian law, assignment of contractual rights can be done without the other party's consent. But the assignment of contractual obligations is only effective with the consent of the obligee. And the second point is that sometimes contract is specified that even in case of assignment, the party who assigns remains liable. So the parties should be aware of these contractual clauses, but all of this can be modified by agreement. The third issue is that sometimes assignment is a bit different when the contract involves a public entity, because these entities are mostly subject to the public procurement laws, such as tender laws and local content laws. And these laws may restrict an assignment. So for example, if the original contract was awarded through a public tender waiver, then another tender waiver may be required for an assignment. So as a conclusion, the issue of assignment, the parties should be aware of both the contractual provisions and also the mandatory rules that may apply to public entities and may limit an assignment.
Okay, very good, thanks. Amir, what are some of the challenges and issues in selling or transferring a business in Iran on the way out?
Some of the general issues that you will have in a sale or transfer of business elsewhere applies here as well, like how to structure a transaction. Is the share deal versus an asset deal? When and how to do due diligence. But I would highlight 3 specific issues. First, finding a financial or strategic buyer for the business may be difficult, and significantly more so if the business is a large one being domestically sold and the purchaser needs to meet some sanction compliance requirements. So finding a clean purchaser may not be readily available unless perhaps the seller is willing to undersell, which brings me to the second issue of valuation, or rather undervaluation, which Farid also mentioned. You know, if you're selling or transferring due to sanctions, you may very likely end up underselling. I only add that the M&A market in Iran is not very active. So the M&A mentality, particularly in relation to valuation, is quite underdeveloped. And a buyer, even a sophisticated buyer, may use inappropriate or even absurd methods of valuation, such as fixed asset pricing, as opposed to, let's say, discounted cash flow. Now, if you find a domestic purchaser and you agree on a deal, a third and perhaps the most significant issue that we discussed is how to transfer the proceeds of sale outside Iran, or how to properly hedge any real proceeds until you could transfer. Now, of course, with a foreign acquirer paying offshore, you will not have an issue.
Okay, thanks. Let me just add one sort of thought at the, it's a thought, it's also a little bit of a reminiscence, but in the hopeful scenario where there's some sort of restructuring of ownership in anticipation of better days, you know, not wanting to completely leave, these things are of particular complexity. And they are the kinds of things that will require, you know, many months of Lucas's time and Farid's input, and in fact we've experienced something like this together in the past. So they are doable, but they're quite tailored to the particular circumstances of the foreign parties and the particular business. But the good news is that they are achievable, but it takes a bit of doing to get it done. Now, since I just mentioned Lucas, let me come back to you, Lucas, to present to you a couple of the other questions that have come in on sanctions. There was one about the medical devices, and there was one about using euro. And then there was another one that just generally says, how can we get paid? You know, so all yours, Lucas.
Thanks very much, Hooman. Well, let me start with the medical exemptions, medical device exemption, sorry. As mentioned, there are several exemptions or general licenses around medical goods in the broader sense, and where your product or the products you want to sell to Iran can be considered to fall under this exemption. These can be exported to Iran without further licensing requirement or otherwise being subject to sanctions restrictions, other than you can sell them to an SDN. If the recipient of the good is targeted by US sanctions, then the exemption does not work. But other than that, medical devices can generally be exported to Iran from a US UN sanctions perspective.
Okay, and what about using euro? Would that insulate someone from OFAC sanctions?
It would not create US nexus, by when not using US dollars would avoid creating a US nexus, and it would at least make more possible to find a bank that would be able to process such transaction. But using euro does not make US sanctions applicable due to the concept of the extraterritoriality of certain US sanctions against Iran, or most US sanctions against Iran, which apply to any person, organization, entity in the world, regardless of them being a US person or not. So it helps if the transaction is otherwise not restricted by US secondary sanctions, but it does not constitute the or heal otherwise sanctions restricted transactions.
Okay, so it helps. It's not a safe harbor, but it helps. Okay.
Exactly.
Okay. And there's a question that says, how can we secure payment of goods sold to Iran? I guess we'd say it really depends on the type of goods and whether your counterparty has funds available outside of Iran, and you know, what exemptions you might fall into or not. So it's quite difficult to say, but the reality is that people do get paid in certain sectors for sale of goods to Iran. Okay, so we have another question which I was gonna, or a cluster of three almost overlapping questions, which I was gonna direct to Farid and Lucas. They are of a comparative nature. You know, one of them was, how does Iran compare to other emerging markets in terms of sanctions and legal risks? You know, Lucas, have you seen a more sanctioned country before, you know, ever? Another question along the same lines is, how to protect against the threat of US sanctions if someone deals with Iran? And the answer to that, I think, is talk to Farid and Lucas, but they'll elaborate. And the third question is, are businesses being asked to choose between doing business with Iran and the US? Is it possible to trade with Iran while protecting US interests? So, gentlemen, for you two, please.
Thank you very much. Farid, shall I start? Has seen a more sanctioned country? The answer is yes. North Korea would be my reaction, mainly because EU sanctions against North Korea are stricter than those against Iran. On the US side, the US, it's particularly the US sanction side, this is where the US administration has pulled out all they can do on the sanctions front, as far as they can get, as targeted as they can get, using extraterritorial sanctions on a very large scale. So compared to other emerging markets, and assume North Korea is not considered an emerging market, I would say Iran is the most sanction restricted emerging market you could currently think of. And the difficulty mainly lies with juggling with all these different sanction regimes and finding your way, navigating your way through. But depending on the sector you're in, there is a way.
Yeah,
to structure business in the sanctions.
If I may add to that, I mean, first of all, it's one of the rare occasions where you're happy that you're not number one. But I'm not sure if it's better to be topped by North Korea but anyway, I mean, one of the challenges that many companies face, or the question was also asked, can do business in Iran and the United States at the same time? And the answer is, as Lord would always say, it depends. It depends on what sector you're engaged in. But let's say pharmaceuticals as one of the sectors that are probably available to operate in Iran. Yes, of course, you're free to operate in the United States and Iran as long as you're sanctions compliant. That shouldn't be an issue. And it does require some internal organization to make sure that you, for example, don't have people from the US business engaging in your Iran-related business. And so a bit of a planning and structuring to make sure that you don't draw funds from the United States and transfer it for Iran purposes. And other things in terms of compliance to bear in mind. But basically, yes, being active in the United States does not, or being active in Iran does not immediately exclude you from doing business in the United States as well.
Okay, we have one remaining question, which is almost unanswerable, but I'll sort of share it with everyone, and then I will, with the permission of the questioner, I'll sort of rephrase it slightly to make it a positive sort of question. The question is, the Iranian economy has been resilient through decades of US sanctions. Will the maximum pressure strategy cause the economy to eventually buckle? If so, how close to buckling is it? And what do we think will be the next move of the US in the event the strategy succeeds? These are all imponderables and mercifully beyond our expertises. But let me ask a question in a sort of in a similar vein, but a different way. Farid, let's say that 4 weeks from now, after the US election, people become optimistic about the direction of sanctions and begin to look again at Iran. At that point, if clients are thinking about engaging or re-engaging with Iran, what would you suggest? What would you advise clients to begin to do to proceed?
Yeah, that's obviously a difficult question, Hooman, and it pretty much depends on how the elections are. But let's say things tend to become more optimistic, and we don't have a second Trump administration. I think probably until the new administration takes over office and the revisit Iran policy, and as long as the sanction situation does not change, it's probably good to sit and wait a few months to see how things develop. Not saying that, and something that we also saw back in 2014, 15, things were already on their way to lead to the JCPOA. Not saying that people cannot start, in terms of being optimistic, start to tap into their long-standing relationships or look into new opportunities at the market, just to not to lose the momentum when things come back quick again. But it's really hard to say, and with the different challenges that the world faces at the moment, I'm not sure if and how Iran will immediately be on top of a new administration's plate, but that could, that could change quickly, and yeah, pretty much depending on whether it's Trump or Biden, but that's really hard to say.
Okay, I'll just share a final thought on that. I think if things go in a way that is more promising, i.e., if it is Mr. Biden who's elected, then I think that there are a couple of things to focus on, and it's basically R&R, research and relationships in the intervening period until there is, as Farid says, real clarity on what happens, because it's not just executive action, but potentially congressional action. So it will take some time. But that period of time can be used to do some research and to develop some relationships, both of which are vital in a country as difficult to do business in as Iran is. The research would involve due diligence. It'll involve learning the problems that others have faced and developing structures to avoid those problems. It will involve learning the lessons of others. The relationships will involve looking for local partners who are trustworthy and with whom you can do business. That is a significant challenge in Iran. And the other part of relationships, I think, is using the networks of your advisors, law firms or others, to kind of learn the market. I know that we and I know Freshfields as well is always open to kind of helping clients connect with others who might be able to kind of help people navigate the highways and the byways and the dead ends in Iran. I will stop talking with that, and thank you, ladies and gentlemen, for your attendance. I see that almost everyone is still intact and with us. I really appreciate that. Thanks to my co-panelists for a very nice job, and let me turn that over to James. There were some questions which we will respond to in writing that came in, which were of a specific nature. So I think I try to drop messages to people who were the subject of those questions. But we appreciate your attendance. Thank you.
Yeah, thanks very much, Hooman, and thanks all our speakers. I'm sharing my screen now with a slide with your contact details. I hope that's coming up for everyone.
I think your screen is showing about 25% of the slide.
Ah, okay, great, fantastic. Well, I'll leave that for now then. So apologies for that failure to screen share properly. The contact details, you'll be able to find them on our website. This video will be posted online, so I encourage you all to ask any further questions you may have to our speakers today. Look, thank you very much. It's been a pleasure. Really interesting session, and from me, a huge keheli mamnoon, if I'm saying that correctly, but thank you very much. Really interesting webinar. Thanks, guys.
That's right. Thank you.
Thanks.
Thanks, everyone.
Thank you.